My name is Chris Bavitz. I'm the WilmerHale Clinical Professor of Law at Harvard Law School and Managing Director of Harvard's Cyberlaw Clinic, which is our technology law and policy clinical program. We have a lot of students who come into the clinic wanting to get their arms around different pieces of technology law. We have students who come in because they have for years known that they wanted to be an intellectual property litigator, or they've known for years that they want to be looking at issues related to algorithmic fairness or promotion of free speech online. But we have just as many students who come in understanding that technology is going to play a role in their law practice career in some ways, but who may be interested in dabbling or trying something new. And we try and cater to all of those. The Cyberlaw Clinic was founded in 1999, shortly after the founding of the Berkman Center for Internet and Society, which is now known as the Berkman Klein Center for Internet and Society. And Berkman is a research institute that conducts a wide variety of research on issues related to the online ecosystem. And I think of the Cyberlaw Clinic in its early days as, in a way, sort of the law and policy advocacy arm of the Berkman Center. It started as a handful of students, 2 or 3 students at a time, essentially sitting on the floor outside Jonathan Zittrain's office working on memos and briefs. The idea is that students would come in and do legal work for clients, and attorneys would supervise that work, and the clients would get the benefit of free legal services, and the students would both learn substantive law related to technology law practice, but also, in some ways, just as importantly, the practical skills one needs to be a lawyer advising companies, individuals, nonprofit organizations, and others on issues related to technology law. At its core, that included issues related to intellectual property, privacy, and online speech. And then over time, our docket has expanded to include technology and human rights, algorithmic fairness and transparency, the impacts of artificial intelligence and machine learning, and legal regulation in all those spaces. These days, we have about 5 or 6 full-time attorney supervisors on the clinic staff and about 30 students a semester. One of the characteristics of the internet in the earliest days of this clinic was that it was very decentralized and very distributed. And that was a great thing, I think. There was a sense that the internet had this democratizing power, that if you wanted to get a message out to a broad audience, or if you wanted to share a piece of music you'd written or a photograph you'd taken with the broadest possible audience, you could plug into the internet and do it. And there was a flourishing of blogs and smaller platforms all around the internet experimenting with the rules that would govern content on those platforms, and offering individuals a megaphone to speak to large groups. The Digital Millennium Copyright Act in 1998 put in place some safe harbor provisions that basically immunized platforms from liability if their users posted copyright infringing materials. There were also just fundamental questions about the copyright implications of sharing content between individuals online. And so my sense of the early docket is that copyright was a big piece of what the clinic was doing. I think that in the last 10 years, maybe the last half of this clinic's existence, we've seen a lot more centralization around a couple of very large platforms whose decisions are extraordinarily influential. We're now experiencing some of the consequences of that, and also trying to think through new ways to control their conduct and the conduct of users online. The clinic experience includes, like most clinics, an enrollment in a course simultaneous with the time the students are in the clinic. And through that course, the students get to experience the full range of work that the clinic is doing. We use a case rounds model, like a lot of clinics use, where a student may be deep down some rabbit holes on 2 or 3 legal issues and 2 or 3 clients that they're really focused on, but they get to come in multiple times during the course of the semester and hear from their colleagues who are working on other legal issues, brainstorming, sharing ideas, recognizing connections and commonalities. The other thing I would say about the student experience, and something that has always been core to the clinic, but it's something we're thinking about today more than ever before, is making sure that the students come away with a sense of what it means to locate the public interest or a sense of social justice in tech work. And we actually have regular conversations in the clinic with our students about whether taking a particular case or advancing a particular client's interests or advocating on behalf of a client for a particular policy position is in fact serving this broader commitment to social justice and the public interest. We've been focusing a lot of attention on the rise of what you could broadly describe as artificial intelligence. You could also talk more specifically about technologies that are algorithmic in nature or technologies that use automated ways to help make decisions. I think we've in particular been thinking about the fact that algorithmic decision-making systems that are trained on bad data may make decisions that are discriminatory in some way. We're increasingly hearing about the use by actors in the criminal justice system of risk assessment scores that assign numerical risks to criminal defendants as part of the process of assessing their eligibility for bail or parole or even determining a sentence. Students are very excited about these issues. They're very hot topics right now in almost every area of law practice, how the use of algorithms, machine learning, and AI are going to impact, again, everything from intellectual property to privacy to speech to consumer protection. And so students are very excited to get to do that kind of work, and we're thrilled to have a lot of those projects in the clinic these days. I think we're going to continue to see a lot of issues arise with respect to technologies that incorporate some version of artificial intelligence. I'm thinking about all of the attention that's been paid recently on questions about facial recognition and surveillance, the ability at a mass scale to detect people's facial features and then perhaps tie them to their actual identities. We are going to struggle to take existing case law on topics like privacy and even due process and equal protection and state law protections against discrimination and apply them in a world where technological decision-making is just going to become very commonplace. I also think we're going to continue to be focused on identifying the public interest and identifying some sense of social justice as sort of our North Star. And again, I think that there are some areas in which the right answer will be obvious, and I think there are going to be lots of other areas in which reasonable people can disagree, and I'm going to look forward to having those conversations with students in the years to come.